Welcome to our presentation regarding gender discrimination. Let's begin. The statute that is most central to the topic of gender discrimination in the employment context is, of course, Title VII. We keep on returning to this. This is, of course, the major statute when we talked about race discrimination and when we talked about national origin discrimination. And it'll be the major statute that we'll talk about when we talk about religious discrimination. This is by far the most important statute that we have in this course. It's not the only one, there are others important ones, but this one is definitely the single most important. So one thing that it can be helpful when you consider a particular statute is to consider the legislative history. Let's talk for a second about what we mean by legislative history. When a law or a potential law is being considered by a legislature, be it the state or the federal legislature, there's a process. When I was a kid, there was this show on Saturday morning cartoons called, I guess it was, I can't remember exactly what it's called, but one of the little commercials they had was called "I'm Just a Bill," and it was this animated bill, in other words, a proposed legislation, and it talked about how if it was going to become a law, how it progressed through the process of going from this committee to that committee, and it would be revised and voted on at various points. One of the points of the little video, "I'm Just a Bill," was to show how difficult it was to go from being a proposed piece of legislation to finally being a piece of law. And so it was kind of an interesting approach. And in each one of those stages, typically there would be hearings or at least debate and discussion about the statute. People would propose changes, some changes would be made, some changes would not be made. And so instead of just considering the final version of the bill, sometimes it becomes relevant, all of that give and take that comes beforehand. For example, imagine that there is a term in the statute that defines the word, let's say there's a term in a statute, the word child, but it's not clear, there's no definition in the statute what child means. That's inherently ambiguous term. Is that somebody who is under the age of 18? Or is that somebody who is the biological offspring of somebody? Maybe the standard is up to the age of 21, or maybe the standard is up to age 16. There can be lots of different levels there. And so one thing that a court might do in deciding which definition to apply would be to consider, what did the members of the legislature think about? And so there might have been a debate. Someone might have said, well, I think we ought to define what child means. And another congressperson might have said, well, we all know what a child means, anyone under the age of 18. And then other people are like, yeah, that's what it means. Yeah, that's what it means. Oh, okay, well, we all agree what it means, so I guess we don't need to change the law after all. Okay, very good, and they pass the law. You could see how that give and take would be pretty powerful evidence that the definition that this group wanted to apply to the term child was anyone under the age of 18. It's not as strong a piece of evidence as if they actually had included that definition in the statute, but it's still pretty strong. So you can see why legislative history is important. And the testimony that happens on the floor of the federal legislature, the Senate or the House of Representatives, is recorded, is transcribed. We have that available. We have available all the different versions of bills and things like that. So there's lots of data to deal with. So, as you can imagine, a very important statute like Title VII of the Civil Rights Act of 1964 caused a lot of discussion. There was a lot of debate. A lot of people had differing perspectives. I mean, this statute was really, really groundbreaking, not just because it conferred rights to all kinds of people, but it was a type of statute that we as a country had never, ever had before. Moreover, it was a statute that it wasn't clear that it was even constitutional. There was a lot of debate about whether it was even something that the Congress had the power to do. So you can see how there's all kinds of interesting issues around this statute. But one thing we don't have legislative history about is about the inclusion of the word sex in Title VII. You might say, well, why do we need legislative history? I mean, sex is pretty obvious. Well, actually, it's not obvious, because does sex include sexual orientation? Does sex include people who are transgendered? Does sex include simply the people who have a particular type of anatomy, but has something to do with cultural stereotypes and cultural values? Does sex have anything to do with sexual harassment? There's all kinds of questions that we have about the term sex, and yet there's nothing in the statute and there's nothing in the legislative history. What actually happened was that initially Title VII didn't include sex as a protected category. A Southern senator proposed that this be added. When he made the proposal, the record reflects that the reaction of the Senate was simply to laugh. They thought it was a joke. Now, there's two theories about why the senator wanted to add sex to the Title VII. One theory was that he wanted to, well, actually three theories, but two of them are closely related. One theory is that he wanted Title VII to fail, and he almost certainly did want that. He was a Southern senator, and at this time in the South, there was a lot of opposition. This is again 1963, 1964, that time period. There was a lot of opposition to the civil rights movement. And so many Southern senators, and senators from other places too, but certainly in the South, were opposed to the civil rights effort and were opposed to Title VII. And so the thought is, well, this senator thought if we added this language about sex, some congressmen and women, probably men, honestly, who might have supported a law that protected the rights of African Americans would not support the rights of women. And so that might be a way of this bill losing some support and maybe not passing. So he could have been using it almost like a poison pill approach. Another possibility is that he was making a point. He was saying, listen, this law is ridiculous. We should not be micromanaging business people's, how they conduct their business. And I'm going to show you how ridiculous it is by proposing a statute that even goes more, it's even more ridiculous than what we have here, but it just demonstrates, well, gosh, I mean, clearly this is ridiculous. And so obviously the protections that we've already discussed are also ridiculous. So it was a way of, by exaggerating what we were doing, it demonstrates, at least in his mind, how silly this proposed statute. So that's the second one, obviously still designed to sabotage or to sink Title VII. The third possibility, though, is different, and that is that this particular Southern senator, though he was very conservative and traditional regarding race relations, was actually fairly progressive when it came to gender issues. He had several staffers who were women at a time where that wasn't as accepted. And so there's a school of thought that says he really did think that if we're going to go through with this law, which he didn't support, we ought to extend those same rights to women as well. So it may not have been an evil intention. It may have been what he thought was good public policy. We don't know. Best guess, though, is there was probably some level of sincerity, but he also was hoping this whole thing would go away. Anyway, little interesting tidbit in history. I like to share that because when we consider these statutes, it's easy for us to approach it through the lens of the 21st century and think to ourselves, well, gosh, no one could oppose this. I mean, this stuff is so obvious. How could anybody think this was a bad idea? And yet many, many people in 1963 and 1964 did think this was a bad idea. And they weren't stupid people, and they weren't, I mean, some of them were probably stupid. They were not as a category necessarily stupid or even necessarily mean or evil. They approached the world looking through a different set of glasses, set of different lenses than you and I do. Can you and I fully understand how they viewed the world? No, because that isn't the world that we live in, just like they wouldn't be able to fully understand our world. But when we talk about the law, especially laws from a long time ago, it's helpful to sit back and think to ourselves, that we're almost entering a time machine when we talk about these things. And we can try to understand, we can try to imagine, but in some sense, we're not going to get there fully. But when we try, we're at least maybe making some progress in that way. So we're going to talk about lots of things. As you can see, we have a pretty clear agenda with respect to this topic. So we're going to get started about, does gender discrimination still exist? But before we talk about that, we're going to talk about our two buckets. When we were talking about national origin discrimination, we had two buckets. This time we're also going to have two buckets. We have our blue bucket, which is our Title VII bucket, and we have our green bucket, which is our Equal Pay Act bucket. We're going to spend probably 70%, maybe even 80% of our time on our blue bucket. I probably should have made a bigger blue bucket here, and then we're going to talk we're going to talk a little bit about our green bucket, but the green bucket is also important. It's important for a few different reasons. We're probably not going to get to the green bucket in this particular lecture, but we will get to the green bucket eventually. But right now, until you hear otherwise, we're in the world of the blue bucket. We're in the world of the Civil Rights Act of 1964, and specifically Title VII of that act. So I'm not going to keep on repeating Title VII, Title VII, Title VII. Just know until you see a screen like this, we're in the world of the blue bucket. We're not talking about the Equal Pay Act. We're not talking about any other statute unless, of course, I specifically say, hey, move it. We're going to take a little detour away from Title VII for a little while. Does gender discrimination still exist? The short answer is obviously. We've seen this in the Me Too movement, and of course sexual harassment is a category of gender discrimination or sex discrimination. We certainly know that sexual harassment continues to exist, but gender discrimination also continues to exist. There's lots of studies that indicate it is a real phenomenon. The law, in fact, protects people, both men and women, from gender discrimination. Certainly, it's more common for women to experience gender discrimination, but we'll see when we get to the Southwest Airlines case, a very clear case, and also the Hooters case, we'll see a very clear cases in which men have been discriminated based upon their gender. It happens on both ways, and both types of discrimination are unlawful. Of course, the vast majority of gender discrimination claims are filed by women, certainly. I'm not going to go through the statistics, but they're pretty powerful that this does continue to be a problem. Let's talk about gender stereotypes. One of the things about stereotypes is that they can have some truth to them. I was at a restaurant the other day. It was a fast casual restaurant where you go to the counter, the person behind the counter kind of prepares what you're going to eat, and then you pay for it and you go about your business. I had been to that restaurant 2 or 3 times. Anyway, I'd had actually some really positive experiences. Several very, very helpful, smart, committed workers were there. There had been an African-American young man, there had been a mature Hispanic woman, there had been a young Hispanic woman who had helped me at different occasions. This time there was a man who was, I would say, late 50s or 60s, Caucasian, and he was very outgoing, very knowledgeable, very positive. And I immediately assumed, maybe assumed is too strong, but I immediately thought there's a good chance he owns this store, this restaurant, this franchise. I never actually got that confirmed, but at a later point when we were leaving, he made a point of kind of coming up and sharing with me some additional information about his business. And so it was pretty clear at the end that yes, he did own the business. But I thought to myself as I was going to sit at a table, I said, why did I assume that he was the one who owned the business? Now, part of the reason was probably because he was older than any of the other people that had helped us, but some of it had to do with the fact that he was a male and that he was white. His age, his gender, and his race were all factors in that. And I think if you did demographic survey, especially in the part of town that we were in, there would be relatively few young people who could afford a restaurant in that part of town. And there would be relatively few African American men who would own a restaurant in that part of town. And there would be relatively few middle-aged Hispanic women who would own a restaurant in the town. So statistically, my assumption that he was probably the owner is correct. But it was also a stereotype, and it was by no means certain. He might not have owned the restaurant. It could have been any one of the other individuals. The reason I'm giving this example is not because it's really important to that particular experience. What I'm trying to point to is stereotypes are part of our everyday experience. We all use stereotypes all of the time. If we didn't, we would be constantly struggling to make sense of our world. Stereotypes are socially useful. Let me give you one that doesn't have a racial connotation to it. When you walk in, or a gender connotation or whatever. When I let me think of it. I guess maybe if we back away from the term stereotype and just talk about experiences, maybe we might even call it common sense conclusions that we might draw from our life experience. We might notice that you know, that one always ought to check, you know, expiry dates, or one always ought to check to squeeze the bread before they purchase. All of those things are the same idea, that we have these life experiences. Many times it's because something has gone wrong, or we've done something enough times to recognize, that's something that can go wrong, or that's something that might go wrong. And we use that experience to think, okay, well now I have this additional knowledge and it's going to impact how I do things. That's how a stereotype develops. The reason why I assume that this older Caucasian man owns the restaurant is probably because I have seen that again and again and again, that people of that age with those particular aspects are much more likely to own restaurants than people who are of different situations. It helps me process all of the data that I'm getting to make some generalizations. And so we do it all the time, but you can see how when we're talking about employment discrimination, making those assumptions can be very harmful to people who aren't older Caucasian men. In other words, women, people who are younger, or people who are older but not in positions of authority, people who are not Caucasian, people who are Hispanic or other other national origins. And so the fact that a stereotype might have some predictive ability doesn't mean that it's an okay thing for us to use. So let's go through some examples here. Let's say that there is a study in a major medical or psychological journal that says, yes, actually women are better at repetitive fine motor skills. On average, women are better. We'll say that the studies indicate women are 37% better at those tasks than men. Can an employer then use that data to only hire women for that job? Or to pay women more who do that job? Absolutely not. Let's say that there is very strong evidence that men are more aggressive in the workplace than women. That it has to do with testosterone or some other hormone. So we're not talking about social social aspects, we're talking about just physiology. A man is going to be more aggressive. And so an employer might say, well, I need some aggressive salespeople, so I'm only going to hire men for those jobs. And because women aren't going to have as much testosterone, they're not going to be as effective in that role, so it's fine for me to do that. And my point I'm trying to make is, even when stereotypes might have some statistical validity, might have some predictive ability, we can't use them. And we can't use them for two reasons. Number one is they aren't going to apply in every situation. Yes, perhaps, again, I'm assuming this study is correct, but it may not be, but let's just assume that yes, on average, men are more aggressive than women. That doesn't mean that every single man is going to be more aggressive than every single woman. It also doesn't mean that there might not be a different way of approaching that job. Maybe being the aggressive salesperson is an approach that works sometimes, but maybe having a different approach that isn't as aggressive may also work. Repetitive fine motor skills. Perhaps women are better at those things usually, but that doesn't mean another person, another man can't be as good or better. And it doesn't mean that every single woman is good at those particular tasks. And even if it happens that on average women are better, there can be individual men who don't meet that particular stereotype. So the first thing is that a stereotype, even when there's some truth to it, isn't going to be true in every single instance. The second thing is the law says we can't consider it. We have to put aside those stereotypes. Doesn't matter if it's valid or invalid, we aren't allowed to consider those stereotypes when we make employment decisions. Now we can have, let's say we have 10 applicants for a particular job that involves repetitive fine motor skills. We can have each one of those 10 individuals do the task, and it might end up that if 5 of them are men and 5 of them are women, we might find over the years of us continuously having this done that about 8 of the women, of the 5 women, usually about 4 pass the test, and usually only 2 of the men pass the test. But we can't ever start saying, well, you know what, we're just not going to interview the men anymore. Or we're only going to interview the men who already have demonstrated skills in this area. We're just not going to be able to consider the gender, even if our intuition, even if our experience points to the fact that the women are probably going to be better, or the men are probably going to be better. Let's talk about glass walls. We've talked about glass ceilings previously. Glass ceilings are barriers, kind of invisible barriers, because you think about glass, you can see through, but you can't actually go through. And so the idea behind glass ceilings are that there's a barrier at some point. Oftentimes it's above the middle management area, where women and minorities have difficulty progressing. It seems like they're doing fine in their career, and then they hit the roadblock and they just can't seem to get higher, even though they see men and Caucasians making progress beyond that glass ceiling. Glass ceiling doesn't seem to affect men and Caucasians, even though these men and Caucasians don't seem to be more qualified or more experienced or harder working or anything than the minorities and women who are left behind. Well, there's also something related to glass ceilings, which are called glass walls. And as we know, glass ceilings are barriers to going up. Glass walls are barriers to going to the left or to the right. And what happens sometimes, what causes the glass ceiling, is that certain paths, lateral paths, Caucasians and men might take, and even though it seems like a lateral path, it prepares them for that next promotion. For example, imagine that to get to be a VP, you have to have some experience working in a foreign office. And so Caucasians and maybe men might, at some point in their career, say, you know what, boss, can you assign me to a foreign office? That's where I want to be. And even though it's not a higher position than the domestic position, there's the knowledge that I'm punching my ticket so I can get to that higher position later on. It may not pay off right now, but in the long run it will. Well, those types of positions, it might be that there's a network, I'll call it an old boys network, but however you want to refer to it, that lets those men and those Caucasians know, hey, if you want to move up to this level, you're going to need to have this experience. And so there's some mentoring going on, informal or formal mentoring. Now, it's not usually that anybody is being secretive about this, that they are intentionally not telling the minorities or the women, but then word doesn't get out completely to those other groups. And so maybe the minorities and the women don't know about, oh, well, yeah, I need to work abroad for a time. Or it could be, yeah, those minorities and women know that, but it's not something that's conducive to their lifestyle. For example, maybe the women are married and have a husband who isn't relocatable. Maybe some of the men might be married, but their spouses are more flexible about where they live. So even though the woman knows that in order to advance to the higher level, she'll need the foreign experience, it doesn't fit with what her family is in a way that it might fit for some men. Same way it could happen with the minority members. Maybe there are lifestyle circumstances that make that difficult for them to make the transition. So again, glass walls may be walls because minorities and women don't know about it, or maybe that they're just walls that are difficult for minorities and women to pass so that they can advance to higher levels. Let's consider the statute of limitations with respect to Title VII. Generally, Title VII has a short period in which an employee has to file, either 180 or 300 days after the discriminatory event. Now, this is assuming that there is one event. Certainly, if a person is dismissed, it's pretty easy to know the date. If it's a sexual harassment case, sometimes the date is a little bit more foggy in terms of exactly what the date is. But 300 days, which is the one that applies in Texas because we have an FEP agency or a state agency that also handles discrimination claims, that's less than a year. And in most statutes, or even most common law claims, the statutory period is 2 years or more. And so this is a relatively short period of time. This applies to all Title VII claims, the 300 days. There is, however, one exception in this area, and I want to talk about it. It's a little bit tricky one to really fully explain, so I'm going to spend a little bit of time talking about Lilly Ledbetter. I think Lilly Ledbetter, well, let me give a little bit of history about Lilly Ledbetter. And some of the specifics I might not be getting right. I don't remember all the specifics, but the flavor of the case is going to be the same. Lilly Ledbetter worked for her company, I think it was Bridgestone Firestone, for many, many years, 20 or 30 years. We'll imagine for a second that she was hired, we'll say January 2nd, 1970. It was after Title VII was law, but it was still the early days of Title VII. On that same day, other people were hired. Men were hired, and Lilly got the same job, we'll say, that Bob got in the department. On that same day that Lilly was hired, Bob was hired, and they were assigned to do the same work. And in fact, over the next 20 or so years, they worked together most days, doing pretty much the same things every day. They never discussed their pay. Lilly had assumed that they were earning the same amount of pay. It was a lockstep system, so you were brought in a certain pay rate. We'll say back then maybe it was $5 an hour, and then you might get a 5% or a 3% increase, and so over time that amount would grow. But in Lily's mind, she was probably earning just about the same as Bob, and probably Bob thought the same. Well, when it came time for Lilly to retire, it came to her attention. I can't remember how. I think there was some kind of paperwork accident. She learned that Bob earned significantly more than she did. And in fact, it wasn't just Bob, but several other men in the department who didn't seem to have more experience, who didn't seem to be necessarily harder working, were earning not a trivial amount more than she was. Well, Lilly filed a lawsuit about this. She felt that she had been the victim of pay discrimination, that she was paid less probably because she was a woman. Well, before they got to the merits of the claim, before they decided, well, yeah, Lilly, you got a good claim, or no, Lilly, you got a bad claim, Lilly had a problem, and that was the statutory period. Let's say Lilly retired. She actually, I think, retired in the mid-'80s, but we'll pretend that she retired on January 2nd, 1990. So she had worked there for 20 years. And what Lilly was saying is, well, gosh, I mean, I lost out on this differential for 20 years. We'll say that Bob was hired in at $6 an hour. And over the years, Bob's pay continued to go up just as Lilly's pay went up. And so it was a fairly significant amount of money if you were to add up over those 20 years. And so Lilly wanted to recover all of those lost earnings. Well, her employer said, well, no, Lilly, I mean, you only have 300 days to file your claim. So you had to file your claim in 1970 in order to advance your claim. Well, Lily's response was, I didn't even know about it. I mean, it wasn't encouraged for us to talk about our pay. It would have been considered rude. I just assumed you were paying us all the same amount. How was I supposed to know? How can you sue about something you don't even know is happening? Well, this case went up to the U.S. Supreme Court, and Bridgestone Firestone won. The U.S. Supreme Court said, Lily, you waited too long to file your lawsuit. You should have filed it in the first 300 days of your employment because that's when the discriminatory act happened. Now, it's important to keep in mind that even though there were wage increases throughout the next 20 or so years, Lily wasn't claiming that those pay increases were discriminatory. She wasn't saying that the person who, for example, adjusted the pay of Bob and Lily, say 6 months before Lily's retirement, had any discriminatory animus. Maybe everybody in the facility got a 3% raise. Bob got a 3% raise, so did Lily. Bob's 3% raise resulted in a higher hourly increase just because his base pay was already higher. So 3% of, $20 an hour is more than 3% of $18 an hour, or whatever the numbers were. But Lily's position was not that the discrimination was continuing. What her point was is that discriminatory event that happened on January 2nd, 1970 was subsequent events were kind of compounding that discrimination. But she lost. She lost in front of the U.S. Supreme Court. Now, Congress, when it found out about this decision, was appalled. They said, no, you've completely, U.S. Supreme Court, you completely misinterpreted the statutory period, and we're going to revise Title VII to make it clear that this is not the way it's supposed to work. And so they amended the law to say every single time that a paycheck issues, if it's based upon a discriminatory pay circumstance, maybe in the distant past, that each paycheck is a new discriminatory event. What that means is that the statutory period restarts. So if Lily Ledbetter's last day of employment was January 2nd, 1990, then she had 300 days from January 2nd, 1990 to file her charge. Or rather, let's put it this way, whatever day that Lily Ledbetter files her charge, she can look back 300 days. Now, that doesn't mean that she gets to say, well, the pay was unfair in 1970 and 1971, 1972. Those she can't do anything about. She can only look back over the last 300 days. And even though she didn't think that anyone who was administering her pay over the last 300 days was intentionally or otherwise discriminating against her, that legacy back from the beginning is still continuing. And so she had the opportunity to at least get some of her back pay. So this is a big change in the law. And it has a lot of problems. Now many of y'all listening to this will probably be thinking, well, gosh, yeah, that's what the answer ought to be. This statutory change is a good one and something that is beneficial. And I'm not going to dispute that, but let's just think about it from the perspective of the employer. So think about Bridgestone Firestone. Lily has filed a lawsuit against it. It's trying to figure out how it's going to respond. If given the new statute, which of course wasn't retroactive, so Lily herself wouldn't be able to sue under the Lily Ledbetter Act, but let's say the next person is able to sue under that law. Well, let's say Sally Smith sues under the law, or Bob Smith for that matter, but anyone could sue under this law. And they say, well, I was paid, my initial pay was artificially low because of my gender. So how can Bridgestone Firestone challenge that? Well, Bridgestone Firestone could go back in its records and figure out who hired Lily Ledbetter. Who completed the paperwork? Who decided which pay raise to give her? They can review maybe her application or her resume, maybe the test results that she took to figure out what was going on there. They could do all of that. But if it's been 20 years, there's a good chance whoever hired Lily is no longer with Bridgestone Firestone. Maybe the person's retired. Maybe the person's passed away. Even if the person is still with Bridgestone Firestone, are they going to remember hiring one person 20 years ago? Are they going to remember the reason that they put Lily in at $5 an hour and Bob in at $6 an hour? Maybe it's not even the same person. Maybe one person handled Lily and another person handled Bob. You can see it's almost impossible to reconstruct what happened under those circumstances. It's hard to know why that happened. It's a good question. I don't blame Lily for being concerned about it, interested in finding that out, but I don't know that it's really possible to reconstruct that. Think about it from the employer's standpoint. Given the fact that now, in some sense, there's an unlimited statutory period, it's putting a lot of pressure on HR departments to document everything. You know, it used to be, I mean, you know, in the past, you know, we didn't have to document how Lily's pay was handled because we knew that any dispute about Lily's pay would have to be filed within 300 days. Probably that person is still going to remember, oh yeah, I hired Lily. The reason why we gave her $1 less an hour is that she hadn't graduated from high school. Bob had. That was the difference. Okay. Or Lily had 6 months less work experience. Oh, okay. Or Lily performed slower on the testing that we did for accuracy and speed in doing a particular assignment. Oh, okay. Or Lily wasn't very impressive in the interview. We hired her, but Bob gave us these particular responses to these questions, and we just felt that he had more on the ball. Okay. All of those could be reasons to legally justify, possibly, have the pay difference. But are those records going to exist? And is anyone going to remember if the records don't exist? So you can see having a change in the statutory period puts additional emphasis upon documenting decisions because you might need to revisit that decision in 20 or 30 years. And you might not be around, so the only documentation that might be available is that paper trail. That's something to consider if you work in HR, the need to document these decisions. Not just to document, but to figure out a way to maintain and retain those records for the long haul. It also means that you have to be clear in those records. You know, the reason that we are paying Lily $5 an hour compared to someone else's pay is these reasons. And so it becomes, this issue puts more emphasis upon records keeping, and it's an important thing for HR departments to be familiar with. It also has to do with how long you're going to retain documents. And what this means is, especially pay-related documents probably need to be retained longer than we used to think they needed to be retained for. Let's talk, we're going to flip from Title VII here. We're going to talk about the Constitution for a second. This is kind of a funky case. Doesn't have any direct applicability to employment, but it's an interesting legal issue. Back in the 1970s, Oklahoma had a different drinking age for women compared to men. My guess is the argument was, well, women's frontal lobe develops earlier than men, and so women have better judgment when it comes to alcohol than men do at this age. And so in Oklahoma, women could buy beer at age 18, but men would have to wait to 21. I'll give you a little story from my own family experience. My parents got married at the age of 19. They were both 19 at the time. My mother could just go and get a marriage license because she was over the age of 18. My father was considered too young to get a marriage license, so His mother had to sign the marriage license because he was not yet 21. So again, the idea was men at that age didn't have as much judgment as women. That same idea, I think the law was probably changed in Texas before 1976, but if it hadn't been changed, this U.S. Supreme Court decision would have likely changed it. And this kind of goes back to the idea of stereotypes. Is it true that women's frontal cortex develops, matures quicker than men? Yeah, I think that's probably a medically true thing. Does it mean that as a statistical average, women have more impulse control at the ages of 18, 19, and 20? Probably the average woman would. At least that's what science probably would suggest to us. And so this law has a certain logic to it, but it is treating men and women differently based upon averages. While there are, I'm certain, many women who are mature at 18, there would also be many women who are not. And while there may be many men who aren't mature at 18, 19, and 20, there would be many men who are. And so what the Constitution says in this area, not directly certainly, but what the standard is whenever there's a gender-based difference under the Equal Protection Clause, the 14th Amendment, the U.S. Supreme Court is going to have an intermediate scrutiny standard. This means that, yes, there are differences between genders, obviously, the biological reality, not only the physiological reality, but also how hormones and different parts of the body develop. And so the U.S. Supreme Court says, yes, we get that there are some differences. We get that, women can become pregnant, men have more upper body strength, differences between the genders. And so sometimes it's going to make sense for us to treat men and women differently. But we don't want to give the legislatures kind of carte blanche. We're not going to say, hey, yeah, there's some differences, so therefore you can do whatever you want. So what they have is an intermediate level of scrutiny. And this scrutiny says that any classification difference has to be reasonable and not arbitrary. Well, the U.S. Supreme Court says this difference was not reasonable and was arbitrary. With intermediate scrutiny, it's possible to win. It's possible for the state of Oklahoma to win some cases involving a difference between women and men. But it's a pretty challenging standard. Most of the time, a difference is not going to probably be upheld. The intermediate scrutiny standard is, of course, easier to pass than the strict scrutiny standard. That's what's the standard that is used for race distinctions. So say a policy or a law that applies to African Americans and doesn't apply to Caucasians, or that applies to Caucasians and doesn't apply to African Americans. Almost never are those statutes going to be held to be constitutional. And so this is, a difficult standard, but not an impossible standard to reach. So this kind of gives us a sense, I think, about how we as a country view differences between men and women. By the way, if you have an interest, I encourage you to listen in to the OIA broadcast of the decision that was rendered by the U.S. Supreme Court. It'll take about 5 minutes, and so it's an interesting take on this. Okay, so let's continue talking about career points where gender discrimination can arise. Of course, the first thing I guess that can happen is that it can be in advertising. An ad that says looking for a salesman, or looking for a fireman instead of a firefighter, a salesman instead of a salesperson, or wanting a feminine receptionist or something along those lines. Advertisements should be stripped of any indication of gender, even terms like, say, a pretty receptionist. Well, we use the term pretty to refer to women. We would use the term, handsome to refer to a man. So you need to kind of scrub that type of language out. Similarly, you have to be aware of application questions. Are the questions that are focused on men versus women questions that might be appropriate for one versus another? I've seen applications from a long time ago where they would ask women on the application, when did you have your last period? And the idea was, we want to make sure you're not pregnant, right? And so you might say that's a very intrusive question. It certainly is, but the idea, it's intruding into a part of the family planning that isn't really appropriate. Or a question for women, are you married, or something along those lines. But probably these days we don't see a lot of gender discrimination issues in advertising and application questions. It's usually when we get into interviews that things get to be a little dicey sometimes. I think the reason why interviews can be more dicey is that they are unscripted. People are talking, and so they're not mincing every word. They're not necessarily considering every a word or every thought that's coming out of their mouths. I like to say that the most dangerous part of the interview for the employer is typically walking from the reception area back to your office to conduct the interview. You know, it's that time period where you don't really know this person yet. You don't really want to talk about their resume because it doesn't, you're not really settled into your spot yet. So you make small talk. Small talk sounds safe. I mean, you're just kind of shooting the breeze with somebody as you walk, really not saying much of anything, but you know, it's kind of uncomfortable to walk next to somebody and not say anything, and you want to put that person at ease. So you start talking about something. And sometimes the things that we grasp for in those moments can be legally dangerous. And so I always suggest for people who interview, have a couple, 2, 3, 4 topics that for that walk to your interview, and also walking that person to the next place, that are safe topics. You know, things that are safe are the weather, the Cowboys, something happening locally, for example, the Plano Balloon Festival, some non-political event that's happening in the world. Let's say there's been a natural disaster in some part of the world, or there's been some kind of uh, uh, a famous person, uncontroversial, yet famous person who's passed away, something along those lines that you can talk about. Have a couple of those topics in mind, or you might even want to use some time to talk about the business. That can be a safe area. One thing I wouldn't talk about would be benefit related issues on that walk, because benefits usually relate to people's family structures. You know, you know, if you're talking about benefits, you might want to say, oh, we've got great dental plans. And then you might be thinking, oh yeah, in fact, braces are covered. And then it's like, oh, well, the only people who care about braces are people who have teenagers, right? So then it's like, well, have you just asked this person whether they have a child who wears braces or might potentially wear braces at some point? So you can see how avoiding benefits of that part of is a good idea, but certainly discussing the firm in more broad terms outside the benefits area can be a good topic, good neutral topic to talk as you walk back to the office. It is illegal generally to ask questions at a job interview that you ask. They are pretty open about what the questions are that can be asked during the interview. I'm going to having a bit of technical difficulties here. Not sure what's going on here. Maybe that's gonna get out of this for just a second. I apologize. There we go. Okay, I apologize for that. Just making sure everything was going okay. There we go. Okay. So, you know, if we're comparing at one extreme, scripted questions, no follow-ups allowed, as being one extreme, to all the way to just don't ask any unlawful questions. There are advantages and disadvantages to both. Having the very regimented system makes it quite unlikely that you are going to ask an unlawful question. So that's a good thing, right? There are two bad outcomes, though, that can flow from having a very well, three bad outcomes. You can have probably more than three, but at least three outcomes that are bad or potentially bad. One is that the interviewers don't get the information that they need. It might be that of the 10 people who are being interviewed, only one of them has some major gap in his or her resume. That's definitely a gap that the interviewers want to ask about. Where is this gap in the resume? And yet they weren't allowed to ask about the question because it wasn't one of the scripted questions. So now they don't know how to handle this one candidate. The candidate interviewed well, had good credentials, but maybe they were in prison for axe murdering their family during that period of time. Or maybe they were just laid off and took a bit of time to find the next job. Those are very different answers. They don't know which one's right. And so you can see how not having that information makes it difficult to make a choice. The second, so it can be, the interviewers may not get the right information. The second thing is that it may cause the interviewers to rely to play the system, to use this or use the system in somewhat surreptitious manners. For example, that situation, okay, well, we weren't allowed to ask Bob why he had this gap in his resume, so we're going to pull up his LinkedIn account. We're not supposed to do that, but nobody will ever know. And so now we pull the LinkedIn account. Oh, we can see that he says he was laid off and that he did XYZ during that time. Okay, so now we understand what's going on. But you can see how it causes people to be a little crafty about how they go about doing things. And sometimes they make assumptions that might be right or wrong. Maybe the assumptions are based upon stereotypes that are not supported by evidence or that are discriminatory. The third thing that can be a problem is that the interviewers may not believe in the system. They may think that this is a rigged system, and so it can create morale problems within the facility if you have this very regimented system. But it does tend to stop unlawful questions from being asked. At the other end, you're probably going to get more of an opportunity to ask the questions that you want to and really find out who the better candidates are. But it does open up the employer for the potential that only certain questions are asked of certain candidates, even though those same questions would be appropriate for other candidates, and perhaps unlawful questions will be answered. There's a continuum there. Each employer has to kind of pick where they want to be on the continuum. There's no immediate right or wrong answer. Let's consider this scenario. So we have Bob. He's interviewing for an attorney for his law firm. He asks married applicant if she is married and when she intends, if ever, to have children. It's hard to imagine any time these two questions would be appropriate. The next interview is Larry. He's a man, obviously. He doesn't ask Larry either one of those questions. Under these circumstances, Mary can claim gender discrimination because she was asked these questions and Larry was not. Now you might say, well, how will Mary know that Larry was asked these questions? That's a good question because, obviously Mary didn't sit in on Larry's interview. Larry didn't sit in on Mary's interview. Larry and Mary probably don't know each other, but it does create the possibility. Failure to hire cases are really hard for employees or people who are potential employees to win because they only have just a little bit of a piece of the puzzle. So there isn't a tremendous amount of risk under these circumstances that Mary's actually going to find out about the questions that were asked of Larry, but still it is unlawful. And of course, employers need to be concerned about the measure of legal risk, certainly, of course, but they also need to be aware of the laws are and just comply with them because that's part of being a good corporate citizen. Even if you think you could get away with breaking the law, that's not an option, or it shouldn't be an option for somebody who is either in the legal department in a corporation or in the HR department of a corporation. Whether you agree with the law or disagree with the law, if it's the law, then you need to comply with it, even if you think you can get away with breaking it. Let's consider a different scenario. Bob's bar employs several bouncers. As we know, bouncers are people who typically kick people out, who maybe are getting a little raunchy or a little loud, or maybe there's the risk of a fight breaking out or something like that. Obviously, to be a successful bouncer, it's helpful to have, a fairly significant size and to have some level of intimidation, so that when you go up to the person, they say, I don't want to mess with you. If you want me to go, I'm going to go. Under these circumstances, Bob has only hired bouncers who are men. He refuses to hire women in that role. But he hires a lot of other women for other positions. There are women who are bartenders, women who are waitresses, women who clean the facility, things along those lines. But he won't hire women as bouncers. Um, Under these circumstances, Bob would be violating Title VII because it's not a bona fide occupational qualification that a bouncer be a male. Now, it might end up that what the reasonable qualifications that Bob would have might result in most, perhaps virtually all, of successful candidates being male. That's fine, but we can't exclude women from the get-go, from even being considered. We might have somebody who's, a martial arts expert, or somebody who's, a woman who's 6 foot tall and weighs 220 pounds, who might be very intimidating as a bouncer. So that would be unlawful for Bob to refuse to consider a woman under those circumstances. Different disciplinary standards cannot be applied to men versus women. Imagine that a man has a certain attendance record and a woman has the same attendance record. Man is terminated, woman is retained. That would be discriminatory. Or vice versa. Man is retained, woman is dismissed. Now, many times in those cases, there's other variables in play. So it might be, say, that let's say the woman was retained, the man was dismissed. Maybe the reason that the woman was retained was because she had been employed significantly longer, whereas the man was a new hire. Well, then that's fine, because it doesn't seem like it's the gender that is causing there to be a different disciplinary approach. Or it could be that the woman had a good reason for missing, whereas the man didn't have a good reason. So as long as gender isn't the reason why the disciplinary rule is applied inconsistently, then certainly the employer is entitled. And of course, we've talked about the prima facie case and the ability of the employer to rebut it, and then the ability of the employee to present evidence that the rebuttal was a mere pretext. That whole schema, of course, applies in employment, in gender discrimination as well. In addition, of course, we can't have gender discrimination in training. So let's consider this example. Bob wants to make sure that all the female employees are given training in computers. It's unclear, I guess, exactly whether Bob is favoring women by giving them additional training, or maybe it's actually kind of an insult. Women are stupid, they need more training. Men are already going to know all this stuff. But whichever one it is, whether he's favoring women or in some sense saying that they aren't as smart as men, either way, by providing differing training, Bob is discriminating. Now, of course, to say, well, women, or no, I'm sorry, not women, workers who are in position XYZ need this type of training, whereas people in other departments may not. That's perfectly lawful. That's also lawful even if it just so happens that most of the people in that position are women. If it's logically tied to what the job responsibilities are, then there's not a problem with offering training to one category of workers and not to another. Seniority systems. This is the idea, you hear this a lot, LIFO. This is an accounting term, last in, first out. And the idea is that the longer you've been in a place, that there's a seniority list. So, if I've been here 10 years and you've been here 5 years and there's a layoff that needs to happen, well, the person who was hired 6 months ago goes first, and the person who was hired 2 years ago goes next, and the person that was hired 3.5 years ago goes next, and it's only now that the 5-year person goes. So it's treated in that way. You can see how seniority systems, at least historically, could have been harmful for women. And even today could be harmful for women, because sometimes women leave the workforce for a period of time, oftentimes when they had young children, and then they regain the re-enter the workforce at some point, maybe when their children are school aged. And so they may tend to have less seniority than men. Generally speaking, seniority systems are lawful ways to treat folks, even if it might tend to discriminate or might have a disparate impact upon a particular group. But if you had a seniority system, for example, that gave more weight to men, that would be unlawful. Seniority systems also have to include, let me give you a little background before I say this one. It used to be the case that when women had children, most of the time their employment ended. And if they wanted to reapply, maybe after 6 weeks or 8 weeks or 10 weeks, they could reapply. And many times then they were treated as a new hire at that point, even though they might have been with the company for 10 years or longer before that time. And so that was held to be unlawful, that they ought to have the original hire date, and in fact the time that they were off for their maternity leave should count towards their seniority. So that's no longer an issue. It's been well established for quite a while that that's how maternity leave ought to be handled. Now, of course, if a woman says to her employer, when I have the baby, I plan to not work any longer, and so I will be resigning at that point, that's different. She's saying, I don't want to continue employment here, so if at some point she decides to reapply, then that would be she'd appropriately be treated as a new hire. Obviously, men and women can't be paid different wages and benefits for doing the same work. A health insurance policy, for example, let's assume that this particular employer provides health benefits for its workers. Well, the benefits have to be the same. So if a man is able to cover his spouse and the children, then the woman has to be able to cover her spouse and the children. I'll give you an example of how this can play out. While I was at JCPenney, the way the benefits were structured is that whichever, JCPenney would always, for employees who are benefited, would provide health insurance for the benefited employee, and would also provide health insurance for the benefited employee's children. But it would only provide health insurance for the spouse if the spouse earned less money than the benefited employee. And the idea here is that, well, if the benefited employee spouse earned more money, then presumably that spouse would be able to get insurance through his or her place of employment. And so there was no need for JCPenney to have to pay for that health insurance when this person would have his or her own employer being able to provide health insurance. Of course, with the JCPenney policy, it was gender neutral. It could be that the man had a spouse, or we'll say a wife, who, of course, at this time when I was there, it was only opposite-sex marriages, but this rule would apply with same-sex marriages as well. So the man might earn less money. The woman, the spouse, the wife, earned more money at her place of employment. So therefore, she would not be eligible for the JCPenney health insurance. She would have to get it through her place of employment. Now, of course, it could be that even though the wife earned more money at her place of employment, perhaps that particular employer didn't provide benefits. So it could present some challenges under those circumstances. As long as the policy, though, is gender neutral, the JCPenney approach would be fine. It's only when they identify female employees as not being able to cover spouses and male employees as being able to cover spouses that there would be unlawful gender discrimination with respect to benefits. You can't have differing conditions or terms of employment. So, for example, you can't have a policy that says, well, this gender can be required to work overtime, but that gender can't be made to work overtime. Or this gender gets to work overtime, but this gender can't work overtime. Or we don't want women working the night shift, that could be dangerous, so we're going to only assign that to men, or whatever the thing is. There shouldn't be any distinctions there. Sometimes these distinctions have historically been permitted because they were perceived of as protecting women. In fact, if you look at many state statutes, there will be still on the books, although they're not enforced, rules about women being entitled to additional breaks than men, or women being entitled to other conditions of employment that were designed to protect them either from the rigors of the working environment, or maybe protect them from the possibilities of assault or things along those lines. Maybe the motive behind those laws was good, but they oftentimes ended up being patronizing, and in any event, they reduced the opportunities that women had. All of those statutes, even the ones that have not technically been removed from the books, Title VII has preempted. Those laws are no longer in effect. I used to routinely visit a facility in a different state, and I would go to the bathroom facility there. I was in my women's, I went to the women's bathroom, and in the women's bathroom area there was this almost lounge-like area attached to where the bathroom was. And I remember asking, why do y'all have like this couch and like almost this living room-ish type area in the bathroom? And they said, well, when we opened many, many years ago, our state law required that there be a couch in the bathroom because ladies might need to lay down and rest in the middle of the day because they might be too exhausted from the strains of work. And they were, of course, being a little bit sarcastic about this. Um, and we just never remodeled. It was the end of it, was the answer. And so I asked, well, do the men's bathrooms have this lounge area? And they go, no, the law didn't require us to give the men this kind of couch area, and so we never gave it to them. Obviously, it would be perfectly fine for this employer to revamp the bathrooms and remove the couch area because Title VII would have preempted those laws. Let's consider this scenario. So EEL systems is the same thing as social systems, by the way. EEL systems hires males and females. Good job, EEL systems. The company mostly promotes men to senior sales executive because the job involves a lot of travel. Management believes that male workers are more suited for jobs that require travel. Um, Even if you might say, well, let's assume that occasionally EEL systems promotes women, maybe single women, or maybe women whose children are all grown. So they might say, well, it's not 100% men. Well, no, just having the idea that we're going to favor men or more likely employ men in that area is a type of gender discrimination, because we can't treat men and women differently in terms of terms and conditions of employment. Now, it might be that EEL systems finds, let's say this is a promote from within company, so they really just consider their current workforce, and maybe there's 20 people who potentially could apply for this job. 10 are men, 10 are women. They might find that, yeah, it actually does work out that many more of the men are drawn to this job that involves a lot of traveling than women. Under those circumstances, there's no problem with EEL looking at the applicant pool and choosing the best from the applicant pool, whether the best is a male or female, without considering gender. And it might happen that because more applicants are men, it might work out that more of these successful candidates are in fact men. But EEL systems can't prefer men for that position because of some kind of idea, either about what people are likely to prefer, or safety ideas, or paternalistic ideas. And of course, we cannot engage in gender discrimination and termination. We can't think to ourselves, well, we can let's say there needs to be a layoff. Well, we'll terminate Sally because her husband's got a good job, and so she's going to be able to make it even if the family loses that paycheck. That's irrelevant. The question is, who is the best, or of the people who if a layoff needs to happen, and there's lots of different ways of doing layoffs. We could do it this a LIFO system, or we could do it based upon performance appraisals. But the one thing we ought not base it upon is our judgment as to who needs the income more, or something, or who is a male or who is a female. By the way, going back to wages, let me flip back here. There was a famous episode of the Mary Tyler Moore Show, a show from the 1970s. It was a sitcom. Anyway, in the show, Mary finds out that her coworker, and she and the coworker largely do the same tasks, earn very different income. And so she goes to the boss and says, "Why does Murray earn so much more than me?" And her boss says, "Well, you know, Mary's got kids and a wife. You're single. You don't need as much income." And of course, that idea that the male is the breadwinner, the male is the primary source of income, is not a lawful idea, and certainly can't be the basis of establishing pay differences. As we saw with race discrimination and national origin discrimination, we have both a disparate treatment and disparate impact idea with gender discrimination. If you're disciplining a person of one gender for a particular action, but you're not disciplining a person of the opposite gender who engaged in the same behavior, then that's going to be unlawful under Title VII. And here's an example we have in this scenario. So Harry and Mary are working on the same team. They're both busy over the weekend for different reasons, and they fail to show up to work the next day. When they return, Harry is given only a verbal warning. Mary is terminated. Again, assuming there's the reason for the difference is Mary's gender, Mary has a good gender discrimination claim. And again, there could be more facts. Harry's been around for 20 years. Mary was just hired 3 months ago. That could be a reason for the difference. Or it could be that the reason why Harry didn't show up was that he was in the hospital. The reason Mary didn't show up is because she, went snorkeling and just didn't want to come back and go back to work. So we need to have more information to fully understand this, but if the facts are just as presented, then Mary would have a claim. The prima facie case model applies. Let's just go over this one more time. There are the 4 things that the plaintiff has to prove. First of all, has to prove he or she is a member of a protected class. In other words, for gender discrimination, he would have to prove he's a man, or she would have to prove she's a woman. Now, I say they have to prove it, but honestly, this isn't a matter in question. I've never seen a case where people are disputing the gender of the plaintiff. The second thing is that the plaintiff has to prove that he or she was qualified for the job. Usually these cases are termination cases, so the person already had the job. So that's not likely to be a big concern. Also, that's usually not a point of contention. Third, the plaintiff has to show that she or he had an adverse job decision against him or her. Well, again, if you're fired, pretty obviously adverse, but it could be failure to hire, it could be failure to promote, it could be demotion, it could be suspension, it could be something else. But again, usually that's not very controversial. So the first 3 requirements in a prima facie case are usually really easily met. The 4th one is a little bit less defined. The usual item that satisfies the fourth requirement is when a person of the opposite gender is installed in whatever that position is. So imagine in this scenario, well, let's drop Harry from the story. So Harry isn't a factor. Mary doesn't come to work. Mary is terminated. Mary certainly is a female. She was qualified for the job because she was already working there. She was fired, so she definitely had a bad impact, adverse impact. And let's say she was replaced by Bob. Bob's a man. So all 4 requirements for the prima facie case are satisfied. If Mary had instead been replaced by Teresa, Teresa's a woman, so Mary has not satisfied that 4th element. But other types of evidence can satisfy that 4th requirement. It's a little bit more involved process to establish that, but other piece of evidence potentially can. So once Mary has proven the prima facie case, we're by no means done with the case. Usually establishing the prima facie case is a very easy thing for the plaintiff to do. So now the defendant gets to say, well, yeah, okay. So plaintiff was able to prove prima facie case, but we have a good non-gender based reason why we made this decision. For example, in this case, Mary was AWOL from work. She should be there, should have been at work, and she wasn't. She didn't have a good excuse. It wasn't her gender. It was the fact that she failed to come to work when she was supposed to. So that's a gender neutral reason for the adverse employment action. So now the defendant has come forward with evidence pointing to a non-gender discriminatory reason. And now Mary has the third step to take, and she needs to prove that it was that the reason given by the employer is a mere pretext, that in reality, yeah, the employer's saying this was why, but actually that's not the real reason. And one way Mary can attack that is by finding people like Harry, who also had failed to come to work and who hadn't been fired and who were, of course, male. And so that comes to that three-step process, the four parts of the prima facie case, followed by the defense, then followed by the rebuttal by the plaintiff. We've seen the same structure again and again, and it also applies in the gender discrimination area. Okay, let's discuss disparate impact. We've talked in most of our cases about disparate treatment, which is the kind of direct type of discrimination where somebody is treated adversely because of his or her gender. And now we're going to talk about when we have a facially neutral policy that is applied consistently, but that tends to harm one gender more than the other. Let's consider this scenario. Mary applies to become a firefighter. She's 5'2" and she weighs 110 pounds. She's denied the position because the fire department requires people to be taller and weigh more. Let's say the height requirement is 5'5" and you have to weigh at least 140 pounds. Now, there are men who are under 5'5", and there are men who weigh less than 140 pounds. But in terms of a proportion of the population, a much more significant portion of women are under 5'5", and a much more significant portion of the population of women are under 140 pounds. So it would tend, a facially neutral policy would tend to have a greater disparate impact upon women. Under those circumstances, the fire department is going to have to show that there isn't a business necessity here. If the fire department can't show that, yeah, you really do need to be 5'5" to perform the firefighter functions, and you really do need to weigh at least 140 pounds to do that, then the policy is going to be held to be discriminatory. The big case in this area is Dothert versus Rollinson. We've talked about this case before. I'm not going to dive into it in great length since we've already talked about it before, but you may recall in this case, Ms. Rollinson, who was a very petite woman, did not weigh 120 pounds, was denied a position as a prison guard. And the state of Alabama said, well, you need to be of a certain size to be safe, for the prisoners to be safe and for the guards to be safe. The U.S. Supreme Court agreed in theory with the state of Alabama, but said that the state of Alabama had failed to prove that 120 pounds was the test. So yes, in theory that they may be able to prove that in the future, but they need to establish that fact. Ideally before they actually put that requirement in. Let's talk about gender plus discrimination. We've talked about gender plus before, but let's do a little refresher. This is when employment discrimination occurs based not exclusively upon gender, but upon some other fact. For example, let's look at this case. Mary is a teacher at a non-religious private school. So it's important it not be religious. We'll talk about why in just a second, but that's an important part of the story. She becomes pregnant before she's married. Her employer, the school, terminates her because it would be bad for the school's reputation. She would be being a bad role model for the students to see my teacher Mary, or Mrs. Mary, whatever, I guess Miss Mary in this case. Miss Mary got pregnant out of wedlock. It's probably just fine for me to also become pregnant out of wedlock. And so you can see how that would be a negative thing for the school. The employer employs lots of women women teachers, so they don't seem to be discriminating in terms of their staffing, but they don't employ women who are unwed parents. But let's say that Mary's significant other is Jerry, a male who also teaches at the school. Well, he's not fired. Now the school might say, well, yeah, but no, but the students don't know that Jerry's the dad. I mean, he's not he's not visibly pregnant. Mary is going to be visibly pregnant just by the nature of the fact that she's going to have the baby, right? But under these circumstances, Mary would be able to assert a gender plus discrimination claim. Now, if both Mary and Jerry were both terminated, then that would probably not be a gender plus case because the employer has been consistent. Now I'm going to go back and talk about this non-religious school thing. If this school were religious, let's say it was a Catholic school or Jewish school or Muslim school or any school having a religious aspect to it, then they could say very possibly that their teachers are in some sense continuing the religious mission of the school and teaching the children the values that are part of that religion. And if the religion prohibits premarital sex, then that would be an example of, by terminating Mary, of communicating consistent with our values and the religious teachings we have, you should not engage in this behavior. So again, it becomes more complicated when it's a religious school versus a non-religious school. As I said before, if men are treated the same way, it's not problematic, but when men aren't, it does become problematic. The famous case in this area is Phillips versus Martin Marietta. I think her name was Myra Phillips. She was told that Martin Marietta was not going to hire her because she had preschool-age kids. The point that Martin Marietta made was, well, preschool-age kids get sick a lot, and daycares won't take them, and so you're going to have to miss work. And that's just a big hassle for us. And so we hire women, but they have to have school-age kids. The idea is, yeah, sometimes school-age kids get sick too, but not nearly as often as preschool-age kids. The problem, though, with Martin Marietta's position was that it hired men who had preschool-age kids. Now, Martin Marietta would say, or did say at this point, well, yeah, but you know what? Usually it's the mom who stays at home with the sick kids. I mean, that's just what our culture does. And you know what? Martin Marietta is not incorrect about that. I'll be honest with you. When my kids were sick, when I had preschoolers, I stayed at home. My husband didn't, for the most part. There were some exceptions, but that was the usual rule. So what Martin Marietta was saying was actually pretty true. Most of the time in our society, even when there's a two-parent family, the mom stays at home with the sick kids. And so there was a logic to Martin Marietta's policy, but again, that stereotype, even when stereotypes are true, can't be the basis of making gender-based employment decisions. So it is not lawful to ask female interviewees if they have proper daycare arrangements for their children, even though in the US, certainly, women are much more likely to miss work due to children's illnesses than are men. Now, if the men are also asked this question, that's fine. But if you're just asking it to the men just because it will appear politically correct, but you care about the answers the women make versus you don't really care about the answers the men make, then you're engaging in discrimination. So you can't, I mean, you can create the appearance of no discrimination. You just have to really not discriminate and not treat men and women differently in this area. Okay, let's talk briefly about gay and transgender individuals. We'll have another module on this, so we'll talk in more detail. This is an area of the law that is evolving pretty significantly. It's difficult to know how quickly it will evolve or in exactly the ways that it will evolve. The first thing to notice is that in our list of categories that are covered by Title VII, sexual orientation is not a covered category, and neither is transgender issues. The Americans with Disabilities Act expressly excludes sexual orientation and transgender as potential disabilities under that particular statute. So we know that it's not covered by the Americans with Disabilities Act. So the only federal employment discrimination statute that could be covered would be Title VII. Many states cover sexual orientation and transgender issues, but Texas does not. I would be surprised if in the short term Texas were to adopt such a statute. I think it's more likely to happen on a national level before it happens in Texas, although certainly things can change, so that's just kind of a predictive thing. At this moment in time, we have only had 2 of our 11 numbered circuits hold that Title VII bars sexual orientation discrimination. That's the 2nd Circuit and the 7th Circuit. By the way, this information here I don't actually have in the study guide, so you may want to make a notation of this. I don't care about you knowing the numbers of the circuits, but I do care about you knowing the 5th Circuit is the one that has Texas. It's a conservative circuit, and at this point, it has said sexual orientation is not covered under Title VII discrimination. Most likely, this issue will eventually be resolved by the U.S. Supreme Court unless Congress were to change Title VII either to make it clear that sexual orientation and or transgender is covered, or they amended Title VII to make it clear that sexual orientation and or transgender is not covered. So we've already talked about that. Let's go forward here. We've already said that transgendered individuals are not covered by Title VII or Americans with Disabilities Act, and Texas does not have a statute in this area. Let's consider this scenario. So Bob works in the accounting department. He undergoes gender reassignment surgery. After that, he prefers to be called Bobby. So the company elects to dismiss Bobby for being transgender. This all happens in Texas. Under these circumstances, Bobby does not have a claim for gender discrimination because as the law currently exists, transgender is not a protected category. Now, this doesn't mean, and this applies both to gay and transgender circumstances, this doesn't mean that all I'm saying is that companies don't have the legal ability to do this. It doesn't mean that it's a good policy. It doesn't mean that you're not going to be on the cover of the Dallas Morning News if you terminate people for this reason. So companies can lawfully do it, but that doesn't make it a smart decision necessarily, or a politically savvy one, or a business savvy decision. Just it does not it's not going to result in a successful lawsuit is what I'm trying to say. So at this point, we're going to end the session, and we will continue in another broadcast covering the remaining topics in our presentation. If you have questions about what we've covered, please feel free to reach out to me, send me an email. Alternatively, come by my office hours. I'd love to sit down and talk with you in more detail about this material. It's been a pleasure spending this time with you. I look forward to seeing you soon. Take care.